Welcome to Davis Malm. We're going to be covering a range of interesting topics that I hope will be informative and interesting to you. All right, I'm going to talk to you about the NLRB, the National Labor Relations Board, and its enforcement of the National Labor Relations Act, the NLRA. There was a case last year called Stericycle, and in this case, there was a new rule that really shook folks up, and it made us have to be very, very cautious about handbook provisions and rules and policies that we put in place for our employees. So as background, you've heard a little bit from Larry and from Michelle about the NLRA. The NLRA under Section 7 protects non-supervisory employees' rights to engage in what's called concerted activity. And concerted activity consists of, I'm going to the second bullet now, the right to engage in activities for the purpose of collective bargaining or other, and this is the important part, mutual aid and protection. So as Larry mentioned, this is sharing of information about terms of employment, about wages, about treatment at work, harassment, discrimination, treatment by bosses, etc. The NLRA also protects in Section 7 the employee's right to join or assist in a union, collective bargaining, and working with one another to address work-related issues and speak about those issues. And then it's followed by Section 8, which makes unlawful an employer interfering with the employee's exercise of those rights through any interference or restraint or coercion of employees with respect to their rights to share in communication and concerted activity that could be ultimately related to union organizing or not. So this decision that came down last year, it establishes new limits that are very, very strict on any policies or provisions that might chill employees' rights to concerted activity under Section 7. And the new standard is that it is unlawful if the policy that you have in place or the handbook provision or the rule that you have in place for employees could be interpreted by an employee as limiting their rights under Section 7 by dissuading the employee who is economically dependent on the employer and what employee is not from engaging in that activity. So we now are looking at all of our policies and practices to determine whether they could be interpreted by an employee as preventing them or coercing them or restraining them from sharing information with coworkers, participating in any kind of concerted activity related to terms and conditions of employment.
Is the could be part of it a reasonable person standard, or is it an interpretation by the court into could?
Good question, and that's the key to why this is so difficult and dangerous, is that it is not a reasonable person standard. The NLRB, who issued this decision, specifically addressed that there could be alternative readings or alternative understandings of a given policy, but if an employee could interpret it as precluding them from participating in any kind of concerted activity, then there'd be a presumption that it's unlawful. Then the burden shifts to the employer to have to prove that in fact it is a legitimate lawful policy. When a challenge rule is determined to have a reasonable tendency to chill employees from exercising their rights, meaning an employee could interpret the rule or policy as precluding them from participating in concerted activity. Again, as I just said, the rule is presumed to be unlawful. And then the burden shifts to the employer to show that this is a legal policy. And the way they can overcome this presumption that it's unlawful is by showing, number one, and they have to show both, that the rule advances a legitimate and substantial business interest, and number two, that the employer is unable to advance that interest with a more narrowly tailored rule. Basically, there's no possible alternative to this rule. So let me ask you this question. Who thinks that a rule that prohibits employees from sharing information about their compensation would be lawful? Okay, no. I mean, obviously a rule under this standard that explicitly prohibits employees from sharing information about their compensation, their terms of employment, benefits, etc., treatment on the job, would be on its face unlawful. But we get into a lot more subtle issues with the policies and rules that I'm guessing all of you have in your handbooks and on the books right now. So let's take a look at this one as an example. Non-disparagement provisions. Okay, a non-disparagement provision is lawful to the extent it precludes statements about the employer that are made with knowledge of their falsity or with reckless disregard for their truth or falsity. Okay, that makes it lawful because we're saying it has to be knowingly false. It has to be you have to recklessly disregard the truth of the statement. But as you can see, it's not your typical garden variety non-disparagement that we usually see, and that I'm guessing some of you have in place, which is that you can't disparage the company, you can't make statements that could reflect negatively on the reputation of the company. Those under Stericycle would be unlawful. Let me give you another couple of examples. So this is one from the case. This is a conduct rule that was determined to be unlawful. Conduct that maliciously harms or intends to harm the business reputation of Stericycle will not be tolerated. You are expected to conduct yourself and behave in a manner conducive to efficient operations. Okay, so far sounds like a good policy, right? Like totally reasonable from the point of view of the employer. Failure to conduct yourself in an appropriate manner can lead to corrective action up to and including termination. Guess what? Unlawful. The idea is that an employee whose livelihood is dependent on the employer could read this and interpret it as preventing them from sharing information about the company, sharing information about terms and conditions of employment, and therefore chill their rights, their exercise of rights under the NLRA Section 7. And I'll give you one more and then we'll move on. Stericycle will not retain a team member who directly or indirectly engages in an activity that constitutes a conflict of interest or adversely reflects upon the integrity of the company or its management. Sounds perfectly reasonable, doesn't it? I mean, why would we allow our employees to do that? But again, unlawful, because an employee could interpret this as precluding them from exercising their rights to concerted activity. So here's what we need to do. Review your handbook policies, all policies, your employment agreements, and your severance agreements. Evaluate each rule or restriction and carefully consider its purpose. Narrow or eliminate the rule if the restriction consistent with the new standards. So if the restrictions could be interpreted as chilling Section 7 activity. And add carve-outs, something Larry mentioned earlier, carve-outs for protected activity under Section 7, so that you say something like, this policy is not intended to prevent you from participating in concerted activity consistent with your rights.